So yeah, I mean, Rochelle and everyone else, if you know someone who registered or should be on, just send them the link directly because we do know something's going on with that link. Thank you so much for that. All right, so we're going to go ahead and get started. Today's discussion. So happy Tuesday. This is the Mondayest Tuesday ever. And you guys are kicking it off with a very, very intense topic, but it's a very timely and needed topic for the real estate professionals. Today's discussion, show me the money, how to review settlement statements and closing costs is our topic for today. It's not the link, it's clicking the pink area to get in. Oh, okay. Let me see if Melissa's still on. Okay. I will okay. I'll email Melissa. Melissa with the board was just on and she just jumped off. But I'll message her that is the issue. Text her. Text her that. Thank you. Wow. It's clicking the pink area. Okay. Melissa, hold on one second. Thanks, Rochelle. All right, so we're gonna go ahead and get started. I just sent that message over to Melissa with the board. Thank you so much for Rochelle for that feedback. Now, today's discussion, show me the money, how to review settlement statements and closing costs. All right, so for those who I have not had an opportunity to meet before, and today's your first time on our Tuesday Experts University RAPV joint lecture series. My name is Ray Cole Jackson. I'm a real estate attorney in South Florida. I am the founder of Title Experts and a number of other brands, but a little bit about myself professionally, my background. I am originally from Florida, Miami specifically, go Heat, right? I got my undergraduate degree from Santa Clara University. My undergraduate degree is from the University of Florida. Okay, Melissa just responded. The University of Florida, so go Gators. Got my law degree from Santa Clara University School of Law in California, where I was the founder of the Real Estate Law Society. Came back home to Miami and got my LLM in Real Property Development from the University of Miami School of Law, so go Canes as well. And I am a proud licensed Florida real estate sales professional. And so the reason I share this background is just to make sure that you guys are just be comfortable asking whatever questions you have. Again, the difference between myself and an attorney that has not been in the transaction space, specifically the real estate space, is we can have a very, very, very pointed conversation about all things real estate. I was 100% in the transactional space before I even became a licensed attorney, right? So some of the brands that I am a founding partner of is Model Mortgage Experts. We operate under what we call the Experts Group. So Model Mortgage Experts, Title Experts, and Transaction Experts. Model Mortgage Experts is our mortgage brokerage. I think that's kind of self-explanatory. Title Experts is our title insurance and settlement services firm. Transaction Experts is our transaction coordination.
Video, there's a slash through that.
Right. So let's make sure we mute as we come in. Today's discussion is powered by Title Experts. Powered by Title Experts. If you have not had an opportunity to work with Title Experts before, we welcome you to experience a Title Experts closing. Some of the benefits of working with Title Experts include, we are an attorney managed firm. Many of you, you may not know, but you will learn today that many closing agents are, you can be a closing agent in Florida without being an attorney. Title Experts is owned, managed, and operated by attorneys. And so that's one of the features and benefits of working with Title Experts. Sometimes legal issues come up in closings, right? Sometimes. We do provide a dedicated closing team, transaction coordinator, regular status updates, and of course, realtor trainings are available. The new contracts are sent to us at contracts@titleexperts.com. General questions are sent to closings@titleexperts.com, and you guys can always reach us at our main number, 561-510-2294. Now, lastly, I want to invite you guys to join Experts University. Experts University is our online, our virtual training and coaching program for realtors. Our most frequent activity is our Thursday huddles. And I will tell you that for the month of June, we are on vacation. We are on summer break. So for the, not until July 6th, we won't have another huddle. But in the meantime, feel free to join Experts University, expertsuniversity.com. You will have the opportunity to catch up on some of the prior huddles that we've conducted. The huddles are specifically for the purposes of providing business coaching over lunch, right? And so we call it bite-sized business development coaching over lunch. Our motto at Experts University is learn more to earn more. And we kind of borrowed that from someone who probably knows a little bit about earning, Mr. Warren Buffett. And so we borrowed that motto, and we have made that the tagline of Experts University, because at the end of the day, as it relates to this class today, guys, every huddle, every event that we conduct and we facilitate is for the purposes of growing your business. It is for the purposes of you guys getting the knowledge, right, so that you can become more competent. You then become more confident, and then that should affect your compensation, right? I'm going to say that again. As you guys learn, you should become more competent. All the time, competency precedes confidence, right? And when you're confident, we know for sure that you are going to earn more, that your compensation should increase, right? And so learn, now learn more. Always, 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 always put yourself in a position to learn more, because I assure you, if done right, your bottom line will show the results of that. All right. So getting into today's discussion, show me the money, how to review settlement statements and closing costs. Now, before we get into the specific figures themselves, one of the main things that we have to do, if those of you have not taken our closing process or title insurance in the closing process for realtors, or potentially you have not had your first closing yet, you may not be entirely familiar with the closing process. So before we get into the figures that's associated with the closing process, let's take a 30,000-foot overview of the closing process itself, right? We know that one of the first steps in the closing process is to make for the buyer to make their escrow deposit, right? To make their earnest money escrow deposit, right? And so that's some figures that you will see on the settlement statement. From that, we conduct our title examination by ordering title searches. Various title searches are ordered. We're going to review each and every one of those. Many of those have figures on them that are going to be included on your settlement statement. So it behooves you to know how to review those searches and how those figures are added to the settlement statement. Next, we are going to, in the title process, we clear those title issues. So those title issues that are identified in the searches, now it's time to address those. From there, once we've cleared title issues specifically, we're working with the lender, and we're balancing our CD. We call it balancing a CD if it's financed. If it's not financed, we're still finalizing the settlement statement, right? And so we're looking at those figures. Finally, we're scheduling the parties for closing. The buyer, if it's a finance transaction, even if it's cash, they're going to receive their cash to close. That's a figure. And then finally, we're going to conduct closing and funds. So that's a 30,000-foot overview of the closing process, right? Escrow deposit, these are your major milestones. Escrow deposit, title searches are ordered, title searches are reviewed and cleared. The lender figures are, the settlement statement is finalized, and this is the meat and potatoes, right, of what we're discussing today, that those settlement statements are finalized. We schedule the buyers and sellers for closing, and then we conduct the closing and fund, okay? So that's the 30,000-foot overview. So let's get into the milestones individually and specifically. The first one, the escrow money deposit. The first step is the escrow deposit. Now, one thing that I want you guys to be aware of, and again, because of the, I'm going to commingle, you guys heard that term before. I'm going to commingle some title and closing terms and coaching or review in this, because specifically the ones that you can never hear too many times, right? The instructions that you can never hear too many times, which includes, as it relates to the escrow money deposit, if your buyer is wiring their escrow deposit, do not pass wire instructions to your buyers. Never, never, ever, 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 ever. Wire fraud is real. Wire fraud is still an issue. And so what we want to do by getting in the habit of never being the party as realtors to pass wire instructions, we're just conditioning our buyers to know that those wire instructions should always come from the closing agent, and that they should always call and verify wire instructions before making any wire as related to their closing. Okay. So what are we saying? Number one, wire instructions never come from you. They always come directly from the closing agent. And the buyer is always instructed and reminded that they'll never come from you, that the wire instructions will always come from the closing agent, and that they should always call and verify wire instructions before they make any bank wire. Okay. Now, outside of a wire, the buyer can make their earnest money deposit by a personal check, cashier's check, and money order, right? So earnest money deposit can be made by personal check, cashier's check, money order, or bank wire, as we just discussed. Right. Now, once the escrow deposit is made, now we are ordering searches, right? We're ordering the searches to clear title. One of the first searches that we are going to order is the title commitment, the title search to prepare the title commitment. The title search is a review of the property's history of documents recorded in the public records. The cost of the title search ranges from $95 to $200, depending upon the closing agent, right? The title commitment is a result of the title search, and it indicates the title issues to be resolved to issue title insurance at closing, right? So that's the first search, and that's our first expense, the title commitment that you're going to see on your settlement statement. Now, the next search that's ordered and the next search that you're going to see is the lien search. The lien search will report matters of record with the municipality, such as tax balances, water bills, permits, and code violations. The cost of the lien search is set by the municipality. This is what's considered a pass-through. So what that means is the lien search is going to cost what it's going to cost, generally regardless of whichever closing agent closes the file, because the municipality is giving the fee for the search, right? There's essentially no markup to that. It shouldn't be. That's a pass-through, right? The association estoppel, that's the third search if the property is located within a HOA or condo association. That's another figure that you're going to see on the settlement statement. The association estoppel, it provides a ledger of the property's account with the association. It will tell us what payments are due. It will tell us any requirements for association approval. It will tell us if there are any violations existing on the property. All of that is reflected in the association estoppel. The cost of the estoppel is set by the association. It is also considered a pass-through. If the property, let's say, for example, is located within a community that has multiple associations, your seller or whomever has agreed to pay for that estoppel could potentially have 2-3 association fees, because each association is requiring a fee for their estoppel. Greg, great question. Greg's question is, does it show special assessments? It absolutely shows special assessments. It shows special assessments that are being charged by the association. So based on Greg's question, let's weave in another concept, because I always bring this up on the contract class. Where is another place that we see a discussion of special assessments? On the purchase and sale contract. But the difference between the special assessments that we see on the purchase and sale contract and what we see on the association estoppels is what? The purchase and sale contract is public body special assessments, right? So let's say, for example, a property has a special assessment for a lighting project. The agreement as to who's responsible for that special assessment is going to be identified in the purchase and sale contract. But the definition of special assessment specifically says in the contract that it does not refer to assessments of your associations. And so this is where you're going to find special assessments for the associations. Got it? So two different special assessments. One is going to be reflected in the contract. That's your public body special assessments. Special assessments that an association would be charging, you're going to find those in your HOA condo association estoppels. Very good question, Greg. Okay. The land survey. That's one of the last searches that we order. A land survey is conducted to confirm the boundary lines of the property and provide confirmation that none of the property structures are over its boundary lines, right? So that's the pool, that's the porch, that's a patio. Those are the items that the land survey is going to review and is going to confirm for us, right? The average cost of a survey is $350. Now, it can increase due to the lot size, right? So we've had closings, the survey was $1,200 because the property was that big, right? So you start getting into acreage, expect the cost of the survey to increase. 350 is your run-of-the-mill, standard single-family home. A survey is not required for condos. Not required for condos. Jerry's question in the chat, I was told that the state regulates the estoppel cost. The state does have regulations, but it specifically caps the cost that the association can charge if the property is delinquent. So there's a difference between what the association can charge if the property is delinquent versus if they are current. It also has it, and there's a cap there. And it also provides for a requirement that if the property cancels, if the transaction cancels within 30 days and you provide that cancellation to the association, then the association should waive or otherwise not require payment for the cost of the estoppel. All right. So to answer your question, Jerry, there's no flat fee that is stated by the state. They just have caps on how much they can charge if the property is delinquent. Okay, so there's no cap. What they charge, what they charge. They just cannot have excessive fees for when the property is delinquent. Could the special assessment also show on the title search? It could potentially show on the title search, but generally it's going to show on the, if it's related to the association, it's going to show on the association estoppel. If it is, you could also potentially see assessments on the lien search, but then also, again, in the contract is where you guys will identify whether or not the seller has knowledge about special assessments that are due and owing, right? And they also come up on the tax bill, which we're going to look at a tax bill in a few slides, and you'll be able to see an area where it could also be reflected. Question in the chat, special assessment should also show on the condo or HOA rider and the seller disclosure. Again, they can be reflected there. The confirmation of the actual amount is going to come from the estoppel. We're not going to go by based on the rider. The rider is going to give you the opportunity to essentially put the buyer on notice. So if you don't have that amount in a rider, now you have an issue, that gets you into the contract class. If there are special assessments that the seller knows that are being charged on the property, that should be reflected in the rider. They need notice. That's the disclosure. If they don't have that disclosure, now you're going to be having a different conversation if that estoppel comes out with the fee that they had no notice of. Now you're potentially in a situation where the buyer can cancel the contract because they had no notice of a special assessment. Tracy's question in the chat, are surveys always included in the search process, or do buyers have to request it? Very good question, Tracy. So if the property is not a condominium and the property is financed, generally a survey is going to be required. The reason the survey is required is because at the end of the closing process, as the title agent, we're responsible for issuing 2 title insurance policies. Well, specifically 1 for owner's policy. If it's financed, then 2, 1 to the lender, 1 to the owner. We have what's called an endorsement, a survey endorsement, which is an additional line of coverage for survey issues. So anything that a survey would identify. If we do not have a survey that we can examine and thereby affirm additional coverage for the survey, then they won't get that coverage. And so to go back to your question specifically, how we get there, the lender is going to require that coverage. And because the lender is going to require that survey endorsement, therefore we're going to need a survey, right? Now, if it's a cash transaction, the buyer's calling the shots. They may say, I don't want that coverage. I'm fine. I'm willing to roll the dice and see whether or not, the property is within its boundary lines. And they have that right, but their title insurance policy at closing will specifically exclude coverage for any issues that a survey would have identified. Okay, so that's a whole little treatise really quickly on that issue. Just so you guys are knowledgeable. No, you're welcome. It's a very good question. So just a recap for those that are coming in and those that are catching up with Tracy's question. When is a survey required? Generally, a survey is required. And the reason why I say generally, because every lender doesn't require it. It could be a private lender that doesn't require it. But generally, if the transaction is financed, if it's not a condominium, the transaction is financed, a survey is going to be required because the lender is going to want a Form 9 endorsement on their lender's policy. If the transaction is not a condominium, and the transaction is cash, then the buyer can make that determination as to whether or not they want a survey order so that they can obtain that Form 9 coverage on their owner's policy. All right, very good questions. Now let's look at the searches themselves so you guys can see how how figures come up in the search results that are then reflected on your settlement statement. So this is a title commitment. This is Schedule A of a title commitment. It's essentially the cover page of the inside of a title commitment, not the jacket. And here is where you start seeing amounts that would be added to the settlement statement, figures that are going to be added to the settlement statement. So I want to draw your eye to requirement 6. This is called requirements. Let me make sure you guys can see my mouse here. Mouse. This is what we call requirements, our Schedule B1. And these are the items, these are the matters that are reflected in the title search that we're saying to the parties, here's what we require, our underwriter is requiring be resolved in order for us to issue title insurance policies at closing. So I want to draw your eye to requirement number 6. It says record satisfaction of mortgage. I see your question, Rochelle. Give me 1 second. Record satisfaction of mortgage from Sandra P. Ayala to mortgage electronic registration system, so on and so forth. So this is a mortgage payoff. You're going to see on the settlement statement, we're going to order a payoff, and you're going to see on the settlement statement the cost to satisfy, to pay off this mortgage so that a satisfaction of that mortgage can be recorded. I want to draw your eye to requirement number 7. It says record release a summary memorandum of agreement and addendum to financing agreement. This is a PACE loan. This is a language that will reflect a PACE loan. And so we are reaching out for a payoff to usually is Y Green. So you're going to see on your settlement statement, a payoff to Y Green for a PACE loan, right? Requirement number 8, it says a notice of commencement recorded in instrument number 116 to give us recording information. That's a contractor's lien. So we're reaching out to the contractor to say, hey, we need a notice of termination recorded for your notice of commencement. A contractor records a notice of commencement against the property to ensure that they're paid. So you may potentially see a contractor's name and a payment amount next to their name because they're owed money for work that was done on the property. So again, this is an example of how figures from the title commitment are added to your settlement statement. It's going to be, generally it's going to be payoffs. It could be code violations. It could be judgments, right? Unfortunately, it could be prior mortgages if that was missed in a prior closing. But this is how we get figures from our title commitment that are added to your settlement statement. Rochelle is saying, what happens if seller provides a survey? If the seller provides a survey, then we will still need to do what we call recertify that survey. So we would reach out to the surveyor that conducted that survey and ask them to go out and confirm that the property is still the same as when they conducted the prior survey. Now, it's supposed to save some costs. I would tell you in practice, it might save you about $100, but it's going to cost you more in time to track down that surveyor, to get them to perform a new survey, so on and so forth. So that's the purpose of requesting a prior survey. But again, generally the cost savings is nominal versus the time it takes to get that facilitated. The number 8 is stating it is paid off. Christy, I'm not sure what you're. I'm not seeing that. So let me know what your question is in that regard. You do not see an amount. Correct. You're not going to see an amount. We have to request the amount. So that does not mean that it's paid off. You don't see an amount in number 6 or number 7. That's where we request payoffs. Welcome to title. Lien search. The lien search, remember we indicated that these the results of reaching out to the municipality, asking them for the status of the property with their different departments, right? So we look at water, we look at property taxes, personal property taxes, they look at waste, they look at the permitting department, code violations, so on and so forth. Now, one of the most common figures that is going to be pulled from the lien search is the water bill. That's just a given. A water bill is just, unless it's a condo with a master meter, pretty much every property is going to have a water bill. And so you're going to see that there. And then you're also going to see a water account holdback. Why? Because the water bill is accruing every day, even if it's just a nominal maintenance fee every day that the water company is charging. And so that's why you see the holdback, because even if a payment is sent today of $51.01, there may be an additional charge of $5 today because we didn't get the payoff until tomorrow. All right. So that's how the water bills are addressed at closing. Now, this lien search is also showing us that there is potentially a code violation, an unrecorded code violation that we could reach out and request resolution of, right? Generally, again, if you guys have taken our title class, remember, unrecorded code violations, open permits are not title issues. Those that are reflected on the lien search, but not reflected on the title commitment, are not title matters that will prevent us from closing and issuing a title insurance policy, because those issues are specifically excluded from coverage under the title insurance policies. Okay? Open permits, unrecorded code violations are specifically excluded from coverage. When we clear title, we're specifically looking at the title commitment. We utilize the lien search for the water bill. We utilize the HOA estoppels for sure we comply with, and then obviously the survey as was previously mentioned. Okay. All right. So we've gotten through the title commitment. We've gotten through the lien search. Let's take a look at the association estoppel. This association estoppel is showing us a lot of information about the financials of this account with the association. So we can see starting at the top that the account is not in collections. We see that the seller was very diligent about making their association payments, and they actually have a credit balance of $3,450. They have a credit that's going to need to be addressed at closing. We're going to need to either credit the seller back, or the buyer is going to be charged for that credit. Either way, that amount needs to be addressed. We're either going to credit the seller at closing, or if you under the circle, it says it also provides instructions that the seller can request a refund, right, with the closing documents. Haran, is that a question or a comment? Because yeah, they do not prevent closing because they are not covered by title insurance. So the parties are made aware, but they're not covered by title insurance. Unrecorded code violations, open permits, expired permits, those are not covered by title insurance. So those are not title issues for the title agent. You guys can under your contract, the buyer and seller can agree that you're not going to proceed to closing without open permits and unrecorded code violations being resolved, and then that will prevent closing. But for our purposes in issuing title insurance, those matters are specifically excluded from title insurance coverage. Okay. So maintenance amount is $1,875. No, very good question. $1,875, and that is quarterly. Quarterly, that means that $1,875 is charged to the parties every 3 months, right? And we're going to talk about prorations, but you're going to see $1,875 on the settlement statement, and then you're likely going to see a proration for who's responsible for the $1,875, depending upon when you close. But ultimately, what you should understand is we see from the HOA estoppel what are the amounts that should be charged and collected from the buyer and or seller. Special assessments. Remember we talked about that just a few minutes ago. This property has no special assessments. There's no accelerated special assessments balance. There's no capital contributions that are due and owing on this property. There's no equity membership. There's no resale fee. There's no transfer fee. The transfer fee is the cost that the association charges to essentially transfer the account ledger from the current owner to the new buyer. You guys are going to see that fee when we review the contract. That's an amount that's on the contract. There's an agreement between the buyer and seller as to who's responsible for that transfer fee, right? And you're going to see it shortly when we look at the purchase and sale contract. And then other fees. Rochelle's question, what if you are financing, the permits are not a concern? The lender may have that as a requirement. Generally, they do not, because the lender just wants their title insurance policy. And their title insurance policy is not going to cover an open permit anyway. So potentially be a lender requirement, but it's not a title requirement. Okay. The next page of this estoppel, you see violations. Remember, we told you, we talked about the estoppel tells you figures. It also tells you whether or not the property has any violations. And so this property had some violations. Clean the roof, remove a hedge, replace a mailbox, read the driveway, debris. Like, they just cleaned this property up at close. They want everything done, right? And so these issues probably was existing on this property for years. And all of a sudden, once they're closing, they want to clean, the association wants the property cleaned up. So this is just an example of some violations, but these do not have any financial obligations attached to it, right? But what if we're coming up on closing and the parties agree to credit the buyer for the cost of cleaning the roof, removing the hedge, replacing the mailbox, weeding the driveway, and debris? That could be a way that these amounts, that these items that are reflected on the HOA estoppel could become a figure. All right, that's a way that this could become money. But the association would also have to agree to allow the parties to close with these violations existing. All right, so we're coming up on closing. Estoppel comes out, all these items need to be resolved. I can't get a roof cleaned in 2 days. I can't get the hedge removed. I can't do all this, but can we agree to a credit? Association, can we agree for the buyer to take on these violations? If the answer is yes and yes, all of a sudden we see a credit on the settlement statement. All right. All right, so we've gotten through the estoppel. The land survey. The land survey. Here's an example of what a survey will look like. The survey does not generally give us any information that is going to require additional monies or costs to be added to the settlement statement beyond the cost of the survey itself. All right. So this is the survey. This is essentially the results, what we call the notes. So you're generally not going to get a survey back that says, oh, you know, charge $500 for something. No. But I don't want to create an issue, but just hypothetically, you guys don't take this and run with it. Let's say hypothetically, this says the fence and shed land in the easement along the north lot line. That's the results of this survey examination. Let's say hypothetically, this does not happen. This file closed just fine. The lender's okay with that because that's not uncommon to have easements. Now, if this shed and fence were in the next property, the next property's boundary lines, we're having a different conversation, right? But landing in an easement, that's common. Driveways landing in an FPL easement, that's common. But let's say, for example, you know, my buyer's particular. My buyer says, I'm gonna have to remove this fence or move this fence back out of the easement, right? And then I want a credit for that. So this does not happen regularly at all, but for the purposes of our discussion, this is potentially how figures can come out of a survey, right? But again, that's not an issue. You generally 99.9999999% of the time, you're not going to have costs that reflected by the survey results. You're just going to have the cost of the survey. All right. So we've gotten through the title commitment. You've seen how costs from title commitment can be added to the settlement statement. The lien search, you've seen how costs from that can be added to the settlement statement. The estoppel, you've seen how costs from the estoppel can be added to the settlement statement. Now the survey, you found out that generally it's just going to be the cost of performing the survey that you'll see added to the settlement statement. Other amounts that you may see added to the settlement statement are escrow holdbacks. And escrow holdback can sometimes be utilized to address pending matters that can be resolved post-closing. If an escrow holdback is agreed to, be sure that the terms are clear on how and when the funds will be released. Escrow holdbacks can be used specifically for matters that do not affect clear title. So we talked about open permits. So let's say, for example, the parties were made aware that there's an open permit on the property. You guys, the buyer and the seller, the agents have been speaking with the city about going out to get the property re-inspected. For all intents and purposes, your understanding is that the work was done just fine. Let's say it was a fence installation. For all intents and purposes, the fence install was done just fine. We're just needing the inspector to go out and inspect the property. They can't go out until next week. We're trying to close this week. Let's just do an escrow holdback for whatever amount you guys agree to ensure that, let's say, what if the inspector, just by chance, stranger things have happened, they said, we need this latch to be changed, whatever, right? Those are types of matters where you can do an escrow holdback and close, and then you'll have those funds released after closing once the parties agree on how and when the funds will be released. All right. One point I want to make to you guys as an aside on this topic, If you're concerned about making sure that the escrow holdback the verbiage is sufficient to cover your bases, grab an attorney. I've seen escrow holdback agreements that were so vague, right? And they're like, well, it wasn't clear under what terms, how and when the funds will be released. And the closing agent is not going to make that decision. They're waiting for the direction from the parties, right? And so if that escrow, if the parties don't agree to release the funds for whatever reason, they get into a dispute, then that money's going to be sitting or it's going to be sent to the court for an interpleader action. All right. So just be clear on that. So that's your escrow holdback. Now, balancing figures with the lender. Now we're getting into the figures that are going to be added to the settlement statement from the lender. Now you guys should know that 80% of the figures that are reflected on the settlement statement under a finance transaction are from the lender, right? And so when your buyer has questions about their origination fees and their tax payments and their homeowners insurance payment, that's from the lender, right? And so even though the closing agent is receiving that information and placing it on the various settlement statements, they don't control what those figures are. They receive that information from the lender, right? So before we look at the settlement statements, know that there are two forms essentially of the settlement statements, right? There is the closing disclosure, and the closing disclosure is utilized when the transaction is financed. It is a federally regulated form that has its requirements as to where and how closing costs are what we call disclosed to the buyer, called a closing disclosure, right? So you see the various sections here. You see section A, B, C, D, E, F, G. And there's even an H and I, J, K, and an L, M, N, O, P too on the next page. But note that the closing disclosure is a federally regulated form. When you have a TRID, we call it TRID transaction, a consumer finance, a consumer loan, and it's going to specifically, it has specific requirements as to where the different amounts are laid out. So let's look really quickly at this. You'll see in section A is the origination costs. Those are lender costs, right? The cost of the lender providing their financing services or the broker providing their loan brokeraging services to the borrower. You see the appraisal fee, the credit report fee, flood certification fee, MCC administration fee, reinspection fee. And this is called what services the borrower did not shop for, meaning the lender directed that those are the vendors that they would use, versus services the borrower did shop for means that the borrower chose those vendors, right? They chose the title, the termite inspection company, they hired title experts to conduct their closing, they acquiesced to ME Land conducting the survey. Why is it called ALTA statement? Very good question, Lauren. ALTA is an acronym for American Land Title Association. That is their form of settlement statement. All right. And this is the ALTA settlement statement. No, very good question. This is the ALTA settlement statement. You'll see the ALTA settlement statement in the next slide. Now, as we get into the settlement statements, calculating closing costs and prorations. Calculating closing costs and proration. This is where we get into utilizing the closing calculator. Question in the chat for Tracy: is there any reason why seller will ask to go with their title company instead? Absolutely, Tracy. So two answers to that question. Number one, if they are, there's two different variations to that. If the seller is negotiating to use their title company to conduct the full closing, that could be for any number of reasons. That's who they work with. That's who they feel comfortable with. They're concerned about the transaction being conducted in an efficient, organized, professional manner, all the things, right? The other option, I think that's what you might be referring to, is what we call seller representation. seller representation is when an attorney represents the seller specifically, their interest in clearing title and really just addressing all of the seller's obligations and responsibilities as it relates to that closing. Now, the reason why I want to make a differentiation between be very specific in saying their attorney, a non-attorney cannot provide seller representation. So you can't just go to any title company and say, can you represent my seller? Even if that's your favorite title company, if they do not have an attorney that is going to represent that seller, prepare documents, clear title, specifically is preparing those documents, then they cannot do that. All right. I'm gonna tell you they can't, they should not, because it happens, but they should not. Only an attorney. Now, a non-attorney is able to prepare legal documents under when functioning as a closing agent, because that's what the statute allows. Now you guys are getting real deep into how this works, but the statute will allow a non-attorney to prepare legal documents such as the deed, affidavit, so on and so forth, when they are drafting those documents under or while performing services as the closing agent for the whole closing. They cannot do that separately as seller representative, right? And then to you just dealt with it, and then to add the final layer of why a seller would go the route of seller representation. The closing agent is supposed to be a neutral, but you guys should know that the closing agent, specifically if they are an attorney, they can specifically represent one party or the other. They can be the literal attorney. For example, I represent the seller, but I'm conducting a closing. That is 100% possible. And guess what? Any issues come up, guess who I'm leaning in favor of? Not doing any violations, but my firm, if any issues come up, they're going to lean more so in the favor of the seller, because that's who we represent. Now, most of your deals your closing agent should be a neutral, right? And they're not leaning in the favor of anyone, but you guys should know and understand that there is, if you have an attorney, they have the ability to represent one party specifically, even as they conduct the closing on behalf of both parties. Okay. Rochelle's question, why is there a charge for title search when buyer or seller pays for title insurance? Cannot do insurance without it first. Rochelle, check that question. Check the second part of your question so I can answer it. So one, we have on the screen an ALTA settlement statement. You'll see at the top on the left, we show the seller figures, what's debited and credited to the seller. On the right, you'll see the buyer figures, what's debited and credited to the buyer. I like this form of settlement statement just simply because it allows you to toggle back and forth. The line item itself is down the middle. The cost of the line item is on either side, depending upon who's being credited or debited for the cost. I just think it's a nice and clean view of the figures. All right. So when you see debit, that means that party is being charged. When you see credit, that means that party is receiving a credit for that line item, right? And ultimately, these debits and credits are going to, once you get to the bottom of the settlement statement, calculate into either an amount that's due from the buyer and an amount that's due to the seller. Once you do this math going all the way down, okay? All right. So there's your escrow deposit. There's your escrow deposit. We have a $4,000 escrow deposit, which is a credit to the buyer, right? It should be, because their purchase price is $265. And so this is where we start getting into making deductions from what they owe. They initially owe $265. To credit them the $4,000 escrow deposit, right? Then we see there's a seller credit here for $4,000. At the top of the ALTA settlement statement is where you're going to see primary charges. You're generally going to see the purchase price, the loan amount, and then any credits to the buyer or seller are going to be up in this section. All right. In the chat, so Rochelle said, why is there a charge for the search when the seller is paying for the title insurance, which is shown by the search? Why is there a charge for the search? There's a cost. There's a cost to abstract title. If I'm understanding your question, there's a cost for someone to take their time to search the public records and create an abstract of title, which is then used to prepare a title commitment. If that answers your question. Gina's question, most attorney-led title services include disclaimer that they're only providing title services. Correct, Gina. Yep. So Gina's saying most times an attorney title insurance firm will let the parties know, hey, we're neutral. We don't represent anyone. We're just performing closing services. All right. Christy said, why debit $4,000 as seller credit line? Because the seller is yep. Okay, Joshua, I think Joshua, you want to teach? But Joshua just answered the question. Because the seller is giving the buyer a credit, they are being charged, right? So debit is charged, credit is being given an amount. Okay. Yeah. Yes, that is what it is, Greg. So prorations. Let's get into proration. And this is a concept that you're going to need to understand so that it looks like, nope. Very good, Christy. So Christy said it looks like the buyer got the credit twice. No, let's look at the line item. I'm going to flip back. This is a very good question. This first 4,000 was what? What does that say? Anybody can drop in the chat. Exactly, it's their escrow deposit. And then this next 4,000 is exactly. And then someone else's question is, what is the lender credit from? It's a lender credit. They gave a credit for something. It might be for a tolerance. It might be for doing business with them before. Whatever the case, that's the credit that they gave. Very good question. So Christy, are you clear why you see that? It just happens to be the same amount, but it's for two different credit types. Good. Very good questions. Very good questions. All right. So now back to prorations. This is an important concept for you guys to understand. All prorations are saying is to allocate proportionately, to allocate a specific amount proportionately based on who's responsible for the amount, right? So generally the day of closing is allocated to the buyer. So you're going to have an amount that is charged for a certain time period. So let's use a very basic example. Let's say we have 30 days in a month and the monthly charge for the association is $30. If we close on the 16th, proration says, and if the payment was already made at the beginning of the month, a $30 payment to the association was paid at the beginning of the month. If we close on the 16th, an appropriate proration will have the seller charge for $14 because that's the number of days in those 30 days that the seller had ownership of the property. And the buyer is the seller is going to be credited because they're going to be charged the 14 and the buyer is going to be charged 16. Yeah, 16. Do my math now. You guys check my math. 14 and 16 is 30. The buyer is going to be charged 16 for the 16 days left of the month. And the seller is going to be credited. So it's a very basic example. $30, 30 days. Proration says Which of those days is the seller responsible for? They'll be charged for that. Which of those days is the buyer responsible for? They'll be charged for that amount. And then the next term is per diem, amount per day. Seller's going to get a credit for 16 days. Buyer's going to be charged for 16 days, Jerry. Because the day of closing, right? So again, per diem is a term that actually isn't on here. We need to add that. Per diem is how much per day. So if it's $30 over 30 days, it is $1 per day. Per diem. What is our per diem? All right. So this is a tax proration example. Now, I want you guys to just listen to this and then ask your questions after you listen, because this can get tricky. And again, you guys are not closing agents. The purpose of today's conversation is for you to understand it, understand the framework, so that when you're reviewing a settlement statement, at least something should jump out to you if it's a problem. Or what if your buyer and seller has questions? The appropriate answer at the end of today's conversation, even if you're not necessarily the expert and able to do this math on a napkin, you'll understand the concept enough to give your clients an explanation of what the charge is, how the charge is calculated, and then say, let's get with the closing agent to confirm the figures. Right? And you're not just like, oh, I don't even know how taxes are paid. I don't even know what ad valorem is, right? You're going to at least have a framework to know what ad valorem taxes are, non-ad valorem taxes are, how they're calculated, and then say to your buyer or your seller, let's loop in the closing agent to confirm how they came up with this figure. All right. So tax proration example, shake yourself and let's listen to this portion. Proration and adjustment for taxes. With taxes in Florida, we generally have two forms of taxes. We have ad valorem taxes, which are value taxes. It's based on the value of the property. And we have non-ad valorem taxes. They are not based on the value of the property. They are charged based on services to the property. Here's what you should know about ad valorem taxes. Ad valorem taxes, again, are value taxes. They are charged in arrears. That means that the amount that is due, the calculation of the payment, the debt for ad valorem taxes, it is due after the fee has been incurred. Ad valorem, in arrears. So they're paid at the end of the year. The fiscal period for ad valorem taxes is January 1 to December 31st. Charges for the value of the property are from January 1 to December 31st of that year. When we close, the seller is going to be charged for the days that they occupy the property. Because again, that bill hasn't been paid yet. That bill is going to be paid at the end of the year. But the seller is responsible for the days of their ownership and the days that they occupy the property. The buyer is going to be credited for the days that the seller occupied the property. Because the buyer, either through their lender, if the transaction is financed, or themselves individually, if they don't escrow and they just pay their taxes outright, they're going to get that tax bill at the end of the year, right? And so they should get some credit for the amount that they're going to have to pay, essentially on behalf of the seller's time period of ownership, right? The tax bill will be issued in November, and generally the last payment is due by March. And you guys probably know that there is a credit for essentially early payment of that tax bill, 4%, 3%, 2%, 1%, until finally they just pay the taxpayer pays the full bill, right? But if it's paid early, they get a 4% credit. The next month, 3%, 2%, 1%. Okay, so that is the ad valorem taxes. That is the biggest property tax amount that you're going to see, essentially, usually. And then you have your non-ad valorem taxes. That is, we're rolling. Hold on one second. That is your non-value taxes. It is not based on the value of the property. It is based on services to the property. And those are the opposite. Those taxes are paid in advance. That is, the payment is due before the fee is incurred. The fiscal year for non-ad valorem taxes is October 1 of the current year that we're closing in to September 31st of the following year. You're shaking your head. Don't worry about it, Rochelle. Just listen, just go with it. Just go with it. Rochelle, you don't have to be a closer. Just go with it. Just know that non-ad valorem taxes, they're calculated in the year that they're paid. It's going to be from October 1 of the year that they're paid to September 31st of the following year. The seller is going to be credited an amount because they would have already paid this amount in their prior tax bill. So for example, when the tax bill is paid at the end of this year, the seller is going to have paid their non-ad valorem taxes for October 1 of this year to September 31st of 2024. Make sense? So when they close, let's say, for example, they close next year, February, they're going to get a credit because they've already paid non-ad valorem taxes through September 31st of that year. Again, just listen. You don't have to memorize this. You just need to know that there's two taxes you're going to see on the settlement statement: ad valorem taxes, which is for the value of the property; non-ad valorem taxes, which are for services to the property. All right. With non-ad valorem taxes, just to finish out this slide, the buyer, the seller, is credited for the days that they will not occupy the property. So think of it this way: the seller is going to be credited for the dates going forward because they've already paid on the non-ad valorem side, and the buyer is going to be charged for the days going forward because the seller has already paid those days on their behalf. That's non-ad valorem. With ad valorem, it's the opposite. So it's being charged for the days leading up to their closing because they have not been paid. And the buyer is being credited for the days leading up to the closing date because those taxes have not been paid. All right. Now, this is what it looks like. This is what it looks like. So county taxes or ad valorem taxes, January 1 to March 2nd, the buyer was credited $505.08. The seller was charged $505.08 because they have not been paid. Those amounts are paid in arrears. The non-ad valorem taxes, March 2nd, that's our day of closing, to October 1, 2020. And this is just a little nuance for maybe give an example or not. This is your example right here, Ken. Non-ad valorem. March 2nd, that's our day of closing, to the day that the end of the payment period, September 31st. This settlement statement, just so you guys know, it shows 10-1 because the way this settlement software reflects it, it doesn't include the date that it stops on it. It goes to the day before. That's a little nuance, just so you know. But this is going to September 31st. So March 2nd, the day of closing, to September 31st, the buyer is charged $1646.49. And the seller is credited because they've already paid that amount, right? Amount that they haven't paid is the non-ad valorem. I'm sorry, it's the ad valorem. The amount that they have paid is the non-ad valorem. Again, understand the framework. You guys will be able to use your closing calculator for this if you would like. The closing agent for sure will verify your figures. You guys just need to understand the framework. You need to understand why you see two different taxes on your settlement statement as real estate professionals in Florida. Okay. Awesome. Glad it's clear. All right. Let's get into the loan charges. Again, these come from the lender. Processing fee. Oh, I tried, Veronica. Let's question, what are services? Sometimes you'll see like fire department, you'll see school, you'll see some roadway projects. You will also see there is, I think they're still charging it. Back in the day, where do you find these numbers? Oh, it's coming up. Very good question, Luana. You'll see it shortly. Trash, yeah, yep. So all those different just services to the property. So let's look at the loan charges. Again, these come from the lender. Processing fee, underwriting fee, termite inspection fee, appraisal fee, credit report, flood certification fee, MCC administration fee. They all come from the lender. Impounds. Do you guys know what impounds are? Those are, this shows that this loan is escrowed. Principal, interest, taxes, and insurance. They are escrowing for homeowners insurance, and they're escrowing for homeowners insurance for 4 months. They're escrowing for property taxes for 6 months. And then there's a lender's aggregate adjustment of 1618. So that's an example of some of your loan charges. Payoffs. Oh, those are from our title commitment, remember? Pay off the SunWest mortgage. And what you'll also generally see is the line items from the payoff statement. So that payoff statement, when it came, it showed, she said she's reviewing the settlement statement. There you go. That's payoff statement. This is for the client. This is so the client doesn't just get 157, 172.40 on their settlement statement without knowing how that figure was calculated. So this is showing the client that the principal balance on the loan was 155,614.19. It showed that the lender was charging them interest through the closing date of $1,073, that there was an FHA insurance charge of $214.66, that the escrow account was overdrawn by $220.05, and that there's a reconveyance fee of $50.50. So all that totals up to 157, 172.40. Okay. And then remember, we also said that there was a payoff to Y-Green. We talked about it said memorandum, and I told you guys that was a PACE loan and that we would need to request a payoff from Y-Green. Well, this is the Y-Green charge is $16,887.07. The principal amount was $16,777.07. And then the payoff processing fee was $110. So Y-Green is charging $110 for to process the payoff. Okay, give me 1 second. Communicating with the board. Aggregate. Give me 1 second. Aggregate adjustment, that's an amount that the lender is charging to compensate. They need to balance out their figures so that it is in compliance. So that's essentially what that figure represents when you see it on the settlement statement. Now, contract closing costs. This is really where you guys should be the strongest in reviewing the settlement statement, because this is on your contract. You should be very clear as to what these figures represent and who's responsible for them. All right. So unlike the property taxes, you guys should be very clear on this because this is in your contract, right? So this is paragraph 9 of your FAR as is contract. Paragraph 9 lays out some standard closing costs, obviously not all of them, but it lays out some of the standard closing costs that each party is responsible for. It's broken out into paragraph 9A, which reflects costs that the seller is responsible for, and 9B, which reflects costs that the buyer is responsible for. And as we go through them, you're going to see if paragraph 9C1 is checked, so on and so forth. We're not going to address those right now. I want to first go through each line item, make sure you guys are clear on what each line item represents. And then we'll go through how you determine who's responsible for each line item, right? So let's start at 9A. Traditionally, the seller is responsible for the doc stamps, taxes, and surtax on the deed, if any. That figure is the taxes that are charged by the county for recording the deed, and it's based on the basically the purchase price of the property. So the purchase price is $550,000. Then the tax is going to be that is required for a $550,000 sale, right? So that's the doc stamps on the deed. Owner's policy and charges. Remember, we mentioned that at the end of closing, the title agent's responsible for issuing 2 policies potentially, definitely one owner's policy and potentially a lender's policy if the transaction is financed. And so the owner's policy is the policy that covers the buyer's ownership interest in the property. So that's the owner's policy. The next cost is the title search charges. Remember, we talked about that title search that's necessary to prepare the title commitment. That's the title search charge. Municipal lien search. We talked about that. That's the cost for the lien search. Remember, we said that was a pass-through. HOA condominium association estoppel fees. We talked about that. That's the cost to order the estoppel. Recording and other fees needed to cure title. That is the cost of recording documents that we need to record to cure a title issue. So let's use, for example, our transaction hypothetical. I think our seller's name was Sandra Ayala. And let's say on our title search, it said that there was a judgment against Sandra Ayala. But our Sandra, let's say Sandra Ayala is a common name. And we show the judgment to our Sandra and we say, hey, this is coming up saying that it is a judgment against you. Is this your judgment? If Sandra says this isn't her judgment, then we're going to have to record what we call a non-ID affidavit, where Sandra attests, I see it as my name, but that's not me. There's a cost to record that title clearing document. That's a seller's expense. That's an example of what that line item is reflecting. Seller's attorney's fees, I think that's self-explanatory. Other, I know you guys usually use that line item for your transaction fee, but fill in whatever you want to fill in there, right? 9B. 9B, the first line item, taxes and recording fees on notes and mortgages. In Florida, we record mortgages, not so much notes. Sometimes the lenders will ask us to record the note as an exhibit to the mortgage, but we generally record the mortgage. Similar to the deed, the taxes that are going to be required to be paid to record the mortgage are going to be based on the mortgage amount. So let's say, for example, $550,000 purchase, buyer only took out a $200,000 mortgage. The taxes assessed to $200,000 are what's going to be the cost to record the mortgage, all right? The next line item, recording fees for deed and financing statements. That is the cost to record each page of those documents. So on your settlement statement, you guys are going to see essentially 3 charges as it relates to recording fees. You're going to see the taxes to record the deed and mortgage if applicable. You're going to see the cost for the pages. The county charges a fee per page. And then you're going to see the cost for what most closing agents utilize, electronic recording vendor. Most use Simplifile. And so there's a fee to use that electronic service, to use that service to electronically record documents. What does that mean? That means that we no longer have to send the physical documents to the recorder's office. They are scanned, uploaded into a portal, and then they are electronically recorded. So those are essentially 3 fees that you're going to see associated with each document that needs to be recorded at closing. Okay. Owner's policy, we talked about that. Survey, we talked about that, the cost of a survey. Lender's title policy and endorsement, that's the cost for the lender's title policy. Now you guys should know that the cost for insurance is promulgated by the state, right? That calculation is promulgated by the state of Florida. So when you guys use the closing cost calculator that we're going to look at, just know that that figure is being pulled by the state, and generally any closing agent that you work with, that insurance cost is generally going to be the same because it's promulgated by the state, right? Now the settlement fee is different. The settlement fee is the cost for the closing agent to perform the work, right? Their time in coordinating closing, clearing title, taking phone calls, all those things that the closing agent do, that's called their settlement fee. That's their fee for doing the work. The HOA and condominium association application transfer fee. Oh, there's their transfer fee. Our hypothetical did not have a transfer fee, but if it had a transfer fee, then you guys see from this that that is a buyer's cost. Municipal lien search, we talked about that. Other, again, you can drop in, you guys oftentimes drop in your administration fee, your transaction fee. Loan expenses, we just went over that, right? That's the processing fee, all those fees that the lender gives us, that's a buyer's expense. Appraisal fees, buyer's inspections, buyer's attorney's fees, all property related insurance, that's like homeowners insurance, owner's policy premium. Now, the last point I want to make with regards to these fees and these figures, this is from your base contract. All of these figures are negotiable. Meaning, let's say you're in a buyer's market. You're in a buyer's market and the seller's like, I'll pay all closing costs. I'll pay the transfer fee. I'll pay for the lender's title policy. I'll pay for the survey. I'll pay for your I'll pay for everything. They can do that. They can do that. But this is essentially your template that you can always negotiate to change, right? So along those same lines, what you all see here on the screen is a graphic of the state of Florida, because the next question is always, well, who's responsible for, how do we know, what do we select, 9C1, 9C2, or 9C3? How do we know? How do we know? What you see here on the screen is a graphic of the state of Florida. And it's showing you that the counties that are in what we call Title Experts Gold, those are counties where generally the buyer is going to select the closing agent. And then there are some other, there are three other elements that move around based upon which paragraph you select, 9C1, 9C2, or 9C3. Understand that what you see here on the screen is what is customary for each county. Meaning, if you're in Palm Beach, the buyer makes an offer saying, I want to select the closing agent and pay for these other fees, then you can do that, even though customarily the seller selects the closing agent. Does that make sense? You guys can, this is what's customary. You can always negotiate and agree to something different. All right. And the counties that are white, those are generally counties where the seller is going to select the closing agent. Now, outside of that, there are three other closing costs that move around based upon which paragraph you select. So I'm going to take you guys back to paragraph 9. And you guys see beside the owner's policy, it says if 9C1 is checked, the seller is responsible for that. If 9C3 is checked, the seller is responsible for the title search. Oh, if 9C1 is selected or 9C3 is selected, the seller is responsible for the municipal lien search, right? Those are the three items that move around based upon which paragraph you guys select under 9C1, 9C2, or 9C3. Here are the four things that move around. One, who's going to select the closing agent? That's the first item that's going to move around based upon, when I say move around, who's responsible for it, buyer or seller? Just listen, you guys are going to have a chart that's going to lay all this out. You're not going to have to memorize this. The first decision is who's going to select the closing agent. The next is who's responsible for the title search costs, which is, again, the search that we use to prepare the title commitment. Who's responsible for the lien search, the cost of the lien search, and who's responsible for the cost of the buyer's or the owner's title insurance policy. Those are four things that move around. All the other figures, I'm going to take you back to paragraph 9. They stay where you see them in your contract. They stay on the buyer side or the seller side. The four items that rotate based upon whether you select 9C1, 9C2, or 9C3 is who's going to select the closing agent, who's going to pay for the title search, who's going to pay for the lien search, and who's going to pay for the owner's policy, right? This is 9C1, 9C2, and 9C3 on your screen. 9C1 says all four of those items stay on the seller side. Seller's going to select the closing agent, seller's going to pay for the title search, lien search, and the owner's policy, along with all the other figures that are under their side under paragraph 9. 9C2 says all four on the buyer side. Buyer is going to select the closing agent, Buyer's going to pay for the title search, lien search, and the owner's policy. 9C3, we call it split the baby. Buyer is going to select the closing agent, pay for the owner's policy. Seller's going to pay for the title search and lien search, right? Here's what it looks like. Here's what it's going to look like on your settlement statement. 9C1, seller selects the closing agent, owner's policy, title search, lien search on the seller side. The costs that are moving around, you see them in the gold. Everything else that's in black is staying as a cost of the seller or buyer, because that's how it's laid out in paragraph 9. Okay. Here's 9C2. Everything is flipped over. You guys see the weight of that? Now it's flipped over to the buyer side. Buyer selecting the closing agent, and now those 3 fees are on the buyer side. Owner's policy, title search, and lien search are on the buyer side. 9C3, split the baby. Buyer selecting the closing agent, buyer's paying for the owner's title policy, seller's paying for the title search and the municipal lien search. Can I go back to 9C1? Sure. Here's 9C1. Seller selecting the closing agent. The 3 charges are on the seller side. Owner's policy, title search, lien search. I was waiting for that question, Christine. Christine says, what's the benefit? Money. It's money. It's money. Talking about settlement statement, right? That's all you see. Well, that's one of the main things. But again, also, it depends on how important it is to either party to make sure that the transaction is with the closing agent that they feel comfortable. Again, it's going to get the deal done efficiently, organized. Okay. Is there an average savings to split to seller? Not necessarily an average savings, but they don't pay for the owner's policy. And the owner's policy alone, rough math calculation off the top of your head is 0.005 of the purchase price. 0.005 of the purchase price. That's just a rough estimate. But again, you guys are going to have the closing cost calculator. You won't even have to guess this. Who decides what to choose? Again, so this is your question, Veronica. I think this is your question. Who decides? This is a map of the state of Florida. And this map is showing you who customarily decides. Right. So we're in, and I'm actually going to have this updated for Miami-Dade and Broward, because that's generally to split the baby. I'll probably make that like gray or something, because that is not all on the buyer side. That's not all buyer selecting and buyer paying for the owner's policy, title search, and lien search. Remember, that is buyer selecting, buyer paying for the owner's policy, but seller paying for title search and lien search. So by the time we do this again, Miami-Dade and Broward will be great, but and every other county will stay the same color. But this will help you. This will help you know. But again, outside of what's customary, when you're getting into dollars and cents, because that's the whole purpose of our conversation today, know that what you select on 9C1, 9C2, or 9C3 is gonna affect the bottom line. Okay. All right. So let's get into the closing cost calculator so that you guys can run these figures yourself. If you guys go to our website, you will see across the top, it says expert estimates, and you will be able to run your own, run these figures. The closing cost calculator, I'm just going to jump out of here and take you guys to the calculator in real time. So this is our website, titleexperts.com. And I know many of you guys probably have access to closing cost calculators, but this is how you would access Title Experts closing cost calculator. You're going to go to our website, titleexperts.com. You're going to go to expert estimates. And when you go to that site, you're going to be asked to log in. I've already logged in, so that's why you see it jumping to the screen. You're going to put in your login information. You can create a user. If you create a user, you'll be able to save all of the searches that you've run. You'll be able to brand these searches. I'm sorry, these estimates, put your photo on it, your logo on it, and then it'll go out to your sellers or your buyers with your information on it. Now, this, as you guys can see here from this drop, wait, make sure you guys can see my screen. Sometimes when you jump out, you can't see. Can you guys see my screen? Yeah? Yes, no, maybe so? Yes, perfect, 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 perfect. All right, so if you go to new estimate, these are all the different types of estimates that you can run. The most common estimate that you guys will run is your seller net sheet. You also have a buyer estimate, the monthly affordability. So very good question, Letitia. It is not an app. What you can do is save this. It is web-based. So save the, hey, Jason, my underwriter is on, guys. Save the, that's so funny. Save the website to your desktop. So you can save it to the desktop on your phone, or you can save it to the desktop on your computer. And the monthly affordability and the rent versus buy. Hello, guys, rent versus buy in this market, you want to be playing with that calculator, right? If you're working with renters and you're telling them, you're trying to express to them why it's more affordable for them to buy in this market versus to continue renting, there's your calculator. But let's look at the seller net sheet for purposes of our training. So we go seller net sheet. And what I did was I already pulled up a property in the Palm Beach property appraisers. And so this is 124 Abaco Drive. And it's predictive. So once you start typing the address, it's going to start making suggestions of what address you're looking for. Let's say our sales price is 500,000. Close date is June 29th. You can change it. Who pays for title? We're in Palm Beach County. So we're saying seller. Let's just use our customary. We can go with that. If you negotiated otherwise, you would do that as well. Manually adjust title fees. You don't need to adjust any title fees manually because there's nothing to your knowledge that you're going to have knowledge of a change in the title fee. So you would leave that. What about payoff? So you're at a listing appointment and the seller says, oh, I do have, to say, Mr. Seller, do you have any mortgages on the property? You say, oh yeah, I do have one, but it's a small amount. It's just $95,000 mortgage. And you say, all right, so is that it? That's the only mortgage. Do you have any lines of credit? Oh, I do have a small HELOC of $25,000. So you put that on there. And then commissions. And they say, well, how much are you going to charge me to sell my property? Right? You know, that's always the question. And you say, well, the rate for my services is 3%. Generally, the buyer's agent is also going to charge 3%. And so it's going to be a total of 6%. And then my brokerage charges a transaction fee of $4.95, right? Homeowners Association dues. Do you have any dues? No, we don't have any association due with this. This property is not in any association, so we don't have any dues, okay? Property taxes. Now for you guys, again, we just talked about your property. We just talked about property taxes. And so we went on the property appraisers page, and you guys would have already started doing some of this research, right? You would have already gone on the property appraisers page to make sure that you're talking to Mark E. Lewis, because Mark E. Lewis is the person that has the authority to engage you to sell the property, right? And you're not talking to Maria. Like, why were you talking to Maria? You're talking to the decision maker, right? So you would have already gone into the property appraisers page. And in Palm Beach County, when you scroll down, you can go to the property tax detail, and the property taxes will jump up on the screen here. And let's do the total amount. So the total tax, here's your ad valorem. Remember we talked about that? Here's the non-ad valorem. Someone said, what are they charging for on non-ad valorem? Drainage district, solid waste. Someone dropped that in the chat. Someone said trash, storm water. All right, so here's some of the non-ad valorem charges Types of non-ad valorem charges that you can see charged to a property, again, is services to the property. Now, for the purposes of our closing cost calculator, we're just going to take the full amount. We're not going to do any breakout of non-ad valorem versus ad valorem because the closing calculator doesn't get that fancy, right? But we're at least going to just drop that amount in here. Other seller expenses and credits. Are we giving the buyer credit, right? We're saying, I know that the pool has a small leak. Or let's not even say that. We're not going that far. Let's say we're giving a credit. Let's say we're giving a credit for a 2-1 buy down. Let's say we know we're in this market. That's a whole separate conversation. You guys are up on the market. Let's say we know that we're going to offer a credit for a buyer to buy down their rate, their mortgage rate, right? So let's say, for example, we say $5,000 credit, right? Calculate. Seller's going to net, based on those basic details, $339,726.01. Settlement fee, $695. Owner's title policy. Remember, we did Palm Beach, right? So the seller's paying for the owner's policy. Title search, they're agreeing to pay for. Lien search, $250. There was no estoppel, so we didn't put in an estoppel fee. Here's an estimate of the doc stamps on that $500,000 purchase. Here's their payoffs, first loan and a second at HELOC. Here are those commissions. Here's your transaction fee. Here's the taxes, credit from the seller. Remember, this is probably going to be a little bit less because this includes non-ad valorem, which the seller is getting a credit, right? But this is a net sheet. This is an estimate. This is how you guys can use this calculator at the dinner table when you're trying to come up with a sales price for your property, right? And so you're not having to do the old school way, reach out to the title company. Can I get a HUD? Can I get a pre-HUD? Like, God, that is so old. That's old, right? You can do this yourself. You can do this at any point. And let's say, for example, this is how you can use these calculators to market for listings. And then you would also use it, like I showed you guys, you can use it for rent versus buy when you're doing your buyer consultations, right? So these are the standard closing costs. And of course, there are going to be some other closing costs that come up and they're transaction specific, but these are the main ones that you can feel confident then sharing this with your clients, with your sellers. You can edit this, you can email it, download it as a PDF. And again, if you log in and create an account, this can be branded with your photo and your contact information so that when you send it to your sellers, it has all your contact information on it. How would I use it for seller marketing? I would be showing them what they connect in today's market. Yes, you access it from the site. Remember, you go right here to our homepage, titleexperts.com, and you go to expert estimates. And once you go to expert estimates, it's going to take you to a login page. You probably saw it really quickly flash through. It didn't stay there because I'm already logged in, but you can do a login. You create a login, and now you're all set. And you guys are just running. I would be running hypotheticals. When Alette, you said how we use this. This is how you marketing money. Hello, seller. This is how much your property's worth. All right. And we say, oh, well, if I don't, and we get into commissions, it's like, oh, that commission's a bit much. You say, well, we could potentially offer 2.5%, right? So let's edit. Let's see. Let's go to commissions. And let's say what the seller says, well, I don't want to give 3%. Why do I have to give 3% to the buyer's agent? And you have that strong conversation with them and say, well, listen, that's what the buyer's agent is paid for working. But let's see what it would, how much we net if we give the buyer's agent 2.5%, right? We calculate. Their number jumped up to 342,226.01. It was 339. So see how quickly you're able to do that, and you're not reaching out for it. Can I get a pre-HUD? Like, no, do this at the table and show them how professional you are. All right. All right. So go log in. Again, go to our website, Expert Estimates, log in, create a user, have fun. Go create all type of scenarios, right? And have fun with that. All right. Hey, Lorraine. Rochelle, is I open, you own the title company in New York? Yeah, well, in New York, you guys are attorney based, right? Rochelle? Oh, there you go. Yeah, you guys are attorney based. All right. So let's get back into finish out our presentation from the current slide. Let's do a share. All right. You guys can see the settlement statement screen, review settlement statement. Awesome. I'm glad, Veronica, I'm glad you're enjoying it. So lastly, you want to review as we come up on closing. Remember, we went over the milestones, is review the settlement statement. Now you guys are 100%, you should be. You have a framework now of how to review a settlement statement. You're familiar with the figures that are identified on settlement statement. You have a framework and an idea of how those figures are calculated, so that if something looks off, you want to go back and check it, you know how to do that, right? You have a closing cost calculator, and then you can reach out to the closing agent. At the end of the day, what is important is that as real estate professionals, thanks, Rochelle, as real estate professionals, along with all the other things you have to know how to do, read appraisals, inspection reports, you should know how to review a settlement statement to at least give an initial response to your buyer, to your seller, on what that line item is referring to, how it's calculated, and then to confirm it, you simply say, we're going to reach out to the closing agent and have them confirm the figures, right? You guys are good now. You guys can tear through a settlement statement now, right? All right. How do I pronounce your name? Sarai Rosine? Can you please get, okay, it is on our website at www.titleexperts.com, www.titleexperts.com, and then go to expert estimates. All right, guys, we did it. Oh, with 20 minutes to spare. We powered through. Questions? Oh, Helen, I'm glad. I'm so glad. Good to see you. You're welcome, Haran. Any questions? Any questions whatsoever? Any questions whatsoever?